Mrs. Burks, the appellant in this matter. May I please reserve 5 minutes?
5 minutes, that'll be fine.
Thank you. Good morning, and may it please the court. We are here on a divorce matter requesting that this court review several issues from a case that was tried in early March of 2022 by a special judge sitting, Don Ash. The first issue in this matter is regarding a unilateral contract. And we're asking you to find the existence of a unilateral contract whereby husband made a promise and wife accepted it via her performance. Now, wife filed for divorce in January of 2018 originally. And in August of 2018, on August 17th to be exact, husband gave her a letter that he had written out that we submit to you was a unilateral contract. Now, husband isn't just any layperson writing this to his wife. He's a lawyer. So there's a bit of a different angle there. He was a very successful lawyer. He was a very accomplished lawyer. At trial, it was proven that between 2017 and 2020, he averaged about $1.69 million per year, or $140,000 a month. He also testified at trial. He quipped that he knew contracts, quote, pretty well. He had also testified at his deposition and was asked about it at trial that he booked contracts in law school or got the highest grade in the class.
The husband wrote this out and gave it to the wife?
Yes, sir.
What did you show that the wife, how did you show that the wife actually accepted it? Assuming it was a contract or proposal, what acceptance did she show? Yes,
sir. So, of course, with the unilateral contract, she's not required to give a promise in return, but rather performance. And so the unilateral contract that Mr. Burks wrote out said that in consideration for her reconciling with me and also dropping the divorce lawsuit currently filed, I agree, et cetera, et cetera. So to answer your question, there was considerable proof at trial that she did indeed attempt to reconcile. And I can point you to several spots in the record if you'd let me do that. On page 199 of the trial transcript.
The record, we can read it, unless you just want to do it. We'll read the record. But unless you just
yes, sir. I think just the most salient points that show that reconciliation happened out of Mr. Burks' mouth, not Mrs. Burks' mouth. So on page 199 of the trial transcript, Mr. Burks is asked on cross, and isn't it true that you and your wife attempted to reconcile for the next 2 years? And he says, attempted to, yes. So he flatly admitted that they attempted the reconciliation. In his trial brief on the first page, second sentence states the same thing, that the divorce action languished for almost 2 years as the parties tried to reconcile their differences. He testified at trial that they also resumed sexual relations after he gave the unilateral contract to the wife. And he testified at his deposition and was cross-examined about it at trial, and admitted that he had testified in his deposition that in 2018 and 2019, he said, we tried our butts off, sorry for the coarse language, to reconcile. So there were all of those instances out of husband's mouth that reconciliation was attempted. She stopped pursuing the divorce action, and in fact, the divorce action was dismissed by the court for failure to prosecute in November of 2019 because she hadn't acted in any way in the divorce case and instead had been working on reconciling her marriage according to this unilateral contract. So we submit that was her performance.
When husband gave her the letter, did she tell him that she wasn't ready to sign it?
There was...
I understand your position, she didn't have to.
Yes, sir.
But did she tell him that she wasn't ready to sign it?
Well, that was what Mr. Burks testified to.
Did she testify to the contrary?
I don't believe so.
Okay, so the only testimony in here is that when he gave it to her, she took it and said, but I'm not ready to sign it.
Yes, and you're exactly right that our position is that that's irrelevant as a function of law. Because
what did she mean when she said, I'm not ready to sign it?
Oh, well, I don't know what she meant. I can't opine as to that. I know that there is no signature blank for her to sign, and that a lawyer created a document that gives terms, uses the word consideration, says marital interest, discusses separate property, uses all these legal terms of art. It's dated, it's signed by him. There's no blank for her to sign.
Ms. Thomas, what do we do if we agree that the unilateral contract was accepted by action and should be enforced? What do we do with the debt on the house? Because the unilateral agreement says, I will give up my interest in our marital residence if these things occur. But
You're
there's
exactly
a debt. So he gives up his interest in the house, so does the residence and the debt that goes with it become her obligation?
So the court's exactly right, that the unilateral contract does not mention the debt. We submit that the debt goes along with the marital residence and that it's all sort of a package deal, just like it's two parcels, they all always refer to as one and as the marital residence, and that the debt is wrapped up in that. But I think that's, that's certainly a question for the court. Our next issue is alimony, and we're asking the court to review the award of alimony. The trial court awarded $13,000 per month of transitional alimony to Mrs. Burks for a time period of 8 years. And our position is that rehabilitation just isn't feasible in this case, and that she should be awarded alimony in futuro. Now, I know the court handles this issue and reviews alimony in futuro, and we're certainly aware of the preference that alimony in futuro is not the type of alimony awarded. But according to the statutory definition of rehabilitation, it just doesn't seem to be that in this case and under these set of facts that there is really an alternative, because Mrs. Burks just can't be rehabilitated and achieve an earning capacity that's going to allow her to have an earning capacity post-divorce like Mr. Burks or like they enjoyed during the marriage. Now, it was certainly well settled, and y'all may have gotten a kick out of some of Judge Ash's comments. It was well settled that the parties had a very high standard of living. It was also well settled and undisputed that Mrs. Burks had not worked outside of the home in over 20 years. So it was a stipulation at trial that was entered that the last time she worked outside of the home was in 2001. It was also a stipulation at trial, and is in the stipulation section of the memorandum in order from the court, that she had earned between $25,000 and $40,000 when she worked prior to 2001. That was it. That was the most she'd ever earned. There was no dispute at trial, and husband testified, and opposing counsel even offered to stipulate that Mrs. Burks had fulfilled her role properly and appropriately and done a good job as a homemaker and as a mother of the party's 3 children, who were 10, 17, and 18 at the time of trial. Mrs. Burks testified that she didn't have any kind of a prospect out there for a job that would earn $1 million like her husband did, or even $100,000, and that she believed she could maybe earn an entry-level salary somewhere.
How old was she at the time of trial?
She was 53, Your Honor. And by the time that the 8-year alimony, it seemed the court awarded because the youngest child was 10, and the parties had decided she would be a stay-at-home mother throughout all of their children graduating from high school. So that 8 years would get to the youngest child's graduation from high school, but then she'd be 61. So we're talking about her trying to enter the workforce at 61. And I've talked already about how successful Mr. Burks has been. This is a long-term marriage of 26 years. The court actually found that Mr. Burks' earning capacity was, quote, massive, and that's on page 1267 of the record in the memorandum in order, and the court made a number of findings just about how impressive his earning capacity is and how impressive his ability had been as a trial lawyer and as a businessman as well. When he was cross-examined about these figures, and we used $91,000 per month as his income for purposes of the child support worksheet. So I'm giving you that 1.7 million average, and that was from 2017 to 2020. But at trial, we agreed on using $91,000 per month for the child support worksheet as a more recent figure, and that's about $1 million a year still. So Mr. Burks was cross-examined that even after his $21,000 per month of expenses that he claimed, and if he paid 35% taxes, he would still net $40,000 left over every month. So the ability to pay was most certainly there. And our final issue, and I know I'm almost out of time for my 10 minutes.
You are. It's running up now.
Okay.
So,
Well, I guess I'll have 4 minutes remaining, maybe.
all right, we'll give you another minute. She has 4 for rebuttal.
Okay,
So
yes, sir.
okay, that's fine. Go ahead.
Thank you. Our final issue is regarding fees at trial. We submitted to this court that the trial court didn't appropriately consider Ms. Burks' fee request because, as the statute requires and states, it's mandatory the court shall consider the following, which includes the amount of fees and expenses and whether they were reasonable under Rule 1.5. And the trial court just ruled from the bench on the final day of trial on March 3rd, 2022, and said, I'm not awarding anybody fees, but you can submit your affidavits later if the Court of Appeals wants to review them. So we're requesting that you do just that based on how that happened.
Thank you. You have your 4 minutes for rebuttal.
Yes, sir, I understand. Thank you.
We'll hear from the appellee.
Good morning, Your Honors.
Good morning.
It's a pleasure to be here. I am Glenna Raymer of the Hamilton County Bar, together with Chrissy Minzy, who's sitting back here with her daughter Pippa. I represent, or we jointly represent Brent Burks in this case. With regard to the 3 issues, there are 3 issues in this case that have been raised by the appellant. With regard to the first one, for the very first time, Mrs. Burks makes the argument that this is a unilateral contract. She never argued that during the trial. Only on the appeal is she arguing that. This is not a unilateral contract. A unilateral contract is limited to those situations where you have a reward offered. The typical case would be a situation where there's a loss.
Would you kind of stand in front of the mic so we can be sure we hear you?
Okay.
Thank you.
I'm not unmindful of the court's admonition about remembering what we say. With regard to the unilateral contract issue, remember that in this case, the trial court was never confronted with this issue. A unilateral contract is a situation where there's a lost animal and there's a reward offered for that lost animal. And the first person to respond to the newspaper ad or the advertisement that might be listed on trees or posts or whatever, the first person to respond is capable of receiving the reward. That is a unilateral contract. A bilateral contract, as the trial court judge did not find in this case, but a bilateral contract would be a promise for a promise. In this case, the trial court judge's findings of fact in this regard were very astute, very practical, very on point. And he made 2 findings of fact with regard to the non-existence of the contract in this case. He said, number 1, Mrs. Burks had 19 months. She had from August of 2018, when this contract was handed to her, or the writing was handed to her, until the divorce was reinstated in early 2020. She had 19 months, and during that period of time, she did not treat this house as her separate property. She didn't make the mortgage payment. She didn't do any action that would be consistent with her belief that this was her separate property. She took no action
Wouldn't she
whatsoever.
have to wait for the husband to cheat before the time started?
Well, that's a good question. You know, in this case, it's a question of when did she actually, if there's a writing, if there's a contract in this case, when did she actually accept? I don't know. You know, in this particular case, I think this was
But
a
had she
writing.
accepted it instantly, it would have been unenforceable because he arguably hadn't cheated yet.
That's true. What I want your honors to understand is that this writing was accomplished by Brent Burks in the context of marital counseling. It is, there's been much made of the fact by the appellant in this case that he's a lawyer. Yes, he is a lawyer. He's a very successful lawyer. He's a good financial provider. He's a good father. He's a good lawyer. There was testimony at the end of the trial about his expertise as a lawyer and the fact that cases are treated differently when he's involved. So there's no doubt about the case, about the fact that this writing was accomplished by him in marital counseling. And there's no doubt that he's a great lawyer. But in this particular case, he wasn't acting as a lawyer when he wrote this contract. He was writing it as a human being, as a husband, as someone who wanted to reconcile his marriage in this particular context. But in this case, if this court were to overrule the trial court judge and make a finding that this was a contract and accepted by Cassandra Burks, she would receive virtually all of the marital property. She would receive all of it. And it would necessitate, in my judgment, it would necessitate a retrial, a remand, right? Because this court would be finding that the marital residence was her separate property. And as such, under the statute, the court would need to reorder the allocation of marital property. Remember that in this case, she got fully 60% of the marital estate. She got virtually everything that the trial court judge could give her. Brent Burks has been punished, and punished severely, in my judgment. I'm not saying maybe that it wasn't justified. Perhaps it was. But the point is, the trial court judge in this case did everything in his power to make her life continue and her lifestyle continue in a way that was untouched by the divorce in this case.
May I go back one moment about the unilateral contract? You said on appeal for the first time the wife refers to the contract as a unilateral contract.
That's right.
What did the wife categorize it to be in the trial court?
She could just called it a contract. It wasn't characterized, Your Honor is correct. It was not characterized as a bilateral contract or a unilateral contract. But on appeal, very distinctly, the wife is now saying that it was a unilateral contract, and I'm saying that it wasn't.
Didn't the trial court evaluate it on the basis of a unilateral contract criteria?
No. Did the trial court judge analyze
the
it?
judge's assessment of what she did and did not do, didn't he evaluate whether it had been accepted based upon unilateral contract, meaning did she drop the divorce action? Did she start paying the taxes and the mortgage on the house? Didn't he evaluate it in that fashion, or if not, in what fashion did he?
Well, he doesn't really say. The memorandum opinion is silent on whether the judge, because it's not germane to the judge's findings. In other words, he found no contract whatsoever. He didn't find a reconciliation, and he didn't find that her conduct was consistent. Remember that Brent Burks testified that her personality was such that if she believed that Brent Burks had given her a contract and that she had fully accepted that contract and he had violated it, that she would have called John Konvalinka immediately. And I believe that to be the truth of the matter. That is totally consistent with her personality. She is, might I say, greedy. In this case, she is very greedy. She is asking for all of the marital estate. She is asking that the house be awarded to her. This is a $2 million property, mind you. She testified, and she had an appraisal, that the house was worth $1.6 million. And this is 5.5 acres on the brow of Elder Mountain. But she testified that it had a value of $1.6 million. The trial court judge found that it had a value of $2 million, but she's asking that that property be awarded to her as her separate property, and that she receive $500,000 in attorney's fees, and that she be awarded permanent alimony. So that's why I'm making the point that she is very greedy. Remember that she received 60% of the marital estate in this case, fully 60% of the marital estate. And
that's treating the house as marital property.
That's treating the house as marital property. She received 60% of the marital property. Brent Burks only received 40%. And the numbers, she received in excess of $4 million, and he received something in excess of $2 million. But when you look at the liquidity involved in this, it's very different. She's going to sell that property. She's going to reduce it to cash. He can't sell his interest in the law firm. There's no way he can sell his interest in that law firm. It is illiquid. He cannot sell his interest. So this.
What do you say about the attorney's fee argument that the statute requires the court to know what the respective attorney's fees are before the court makes a decision of whether to assess them against the other spouse or not?
Well, that's a good question. The record is silent in terms of Mrs. Burks's income and expense statement and her proposed division of asset. In neither one of those two documents, one is Exhibit 1 and one is Exhibit 6, in neither one of those documents does she list an outstanding attorney's fee. So, nor does she, I think respectfully, Your Honors, that she did not have it completed by the time of trial. But she didn't list it, and recall that she said that Exhibit number 1, which was her listing of her expenses and her income, she said that she looked at an entire year and divided it by 12, and that's how she came up with her expenses. And nowhere in that document does she list that she's paying attorney's fees. Likewise, in the distribution of her assets, she doesn't list it as a marital liability. Now, to me, it's a real open issue as to whether or not the old statute or the new statute applies. But in either case, I think if this court were to overrule the trial court judge, again, it would require a remand on that issue. And the reason it would require a remand is that in any case, the court would have to make a finding that that fee was reasonable. Remember that she is seeking an attorney's fee in excess of $400,000, 3 times the amount that I charged Brent Burks. And to inject some levity, all of you are familiar with John Convalinka, who is known for his aggressive, ferocious representation of all individuals. In this case, she fired John Convalinka on the eve of trial, fired John Convalinka, who is as aggressive as anybody possibly can be. She fired him and hired Larry Hayes, and in 6 months, they ran up a bill of $400,000, of which she apparently didn't pay any of it. Are there specific questions?
I hear none.
Pardon me?
I hear no questions. Nobody has a question.
Okay. Well, let me just close by saying that Brent Burks is really a super person. And he's been treated very harshly. His monthly outgo in this case is significant. In the appellant's brief, they made much of the Egan's case, which in that particular case, Mr. Egan's earned more than $3 million one year, and he was court-ordered to pay $17,500 per month in alimony. In this case, Brent Burks pays more than that because he pays $13,000 a month in alimony, plus he's making the mortgage payment. When you add those two together, it's more than Mr. Egan's was ordered to pay. So respectfully, Your Honors, I would ask the court to affirm Judge Ash in all respects. He made significant findings of fact. He took a long time to issue his decision in this case. It is many, many pages in the transcript, and he did an excellent job. He made findings of fact with regard to every component, every factor required under the alimony statute, and there are 12 of them. He made findings of fact with regard to every one.
Thank you. We're here from the appellant.
So first, we did raise the unilateral contract issue in the trial
If you
court.
would,
Oh, I'm sorry.
thank you.
We did indeed raise the unilateral contract issue in the trial court. Our trial brief is page 962 of the appellate record, and on page 16 of our trial brief, I just pulled it back up, and we briefed law on unilateral contracts. Tennessee law distinguishes unilateral contracts, such as the one at issue in this case, from bilateral contracts as follows. And there's a big quote from Road Oil Company, Inc. versus Lamar Advertising, one of the same cases that we have cited in support of the unilateral contract in our brief. So not only did we try the factual issues surrounding the unilateral contract, we did indeed also brief that up.
Your client received the marital, or the residence,
Yes, sir.
and husband was ordered to pay the remaining mortgage.
Yes, sir.
If we adopt your position and say, no, that was her separate property, I never quite understood your answer to Judge Clement's question. Is she going to be responsible for the mortgage?
Our argument is that the mortgage is part of the property, and that such that the agreement he was making with her was that she would take the property free and clear, essentially, that she would get it and she wouldn't owe anything on it.
Okay. And if that's so, how's she going to get any more than she already got? She's got the house. She's got husband paying the mortgage on it. And you're asking that, no, the house should have been her separate property.
Yes, sir, based on the contract.
I understand why. I'm asking what difference that would make. Then we'd have to send it back, wouldn't we, to decide the property division based upon your client having a $2 million piece of separate property.
I completely agree that the case would have to be remanded. Judge Ash did indeed divide approximately 60-40 the marital assets. So,
and if you took that out and made the $2 million hers,
yes, sir.
the house, and him still liable for the mortgage, what would the division be?
Well, I think that Judge Ash would probably need to.
Well, I'm sorry. If you just left it the way it was divided, but said, no, this $2 million was not marital property, that was her separate property, and didn't change anything else.
I don't know the percentage on that. I apologize.
Well, I mean, we can look at it, can't we? Because the amounts are there.
Sure.
Would it still be, would them be pretty close to 50-50?
I'm not sure.
I'm not either. I haven't done the math either.
I'm
Okay,
not sure.
thank you. I'm sorry. Go ahead.
Yes, sir. So regarding the outstanding fees, I would submit to the court that certainly the new law doesn't apply, because the new law was passed by the Senate March 31st, 2022, and by the House on April 4th, 2022. Now, we had this trial March 2nd and 3rd, and the court orally ruled from the bench on March 3rd, 2022, so that had already happened before this new law ever went into effect regarding marital debt. And as I know the court recalls, the old case law said that attorney's fees weren't marital liabilities, and we weren't supposed to be listing them on asset and liability sheets. So that's why we didn't do that. And of course, typically when trial courts consider fees, you submit your fee affidavits shortly thereafter so that it can include the amount for the trial fees as well. And it looks like I'm out of time.
Yes.
Thank you so much for the court's time today.
Court's thanks to all counsel. We appreciate your arguments today and your briefs on this.